Welcome. This is the marriage guide for custody and visitation. If you're contemplating a divorce or going towards a divorce, then you need to focus on the custody agreement. And if you focus on the custody agreement, then there's no need to pay child support. Remember, child support is voluntary. By the way, I am not an attorney, or I don't play one on TV. This is my simple guide to getting a divorce and organizing your custody agreement. Let's get started. Trust me, nobody wants a divorce. However, if your spouse telling you that she wants a divorce and she's going to take the children or get full custody of the children, then what should you do? Well, I will walk you through the process of filing a divorce and settle your custody agreement. When you're going through a divorce, your kids are a priority. The battle for custody is very, very important. You want access to their education, school activities, sports. You want weekly visits, vacations, holidays, as well as you want medical decisions, prescriptions, any serious ailment. In other words, your kids are very, very important. The first thing you need to do is get a hold of your finances. In other words, how much you make, how much you owe in credit card debts, insurance. You need to just take a look at your financing. In addition to your finances, you need to know your taxes. Remember, you're going through a divorce. You're not going to be filing jointly. You're going to be filing separately. The reasons why you want to be aware of your finances because you're going to go through the process of called division of assets. Remember, it is all about the money, and you don't want to be surprised, and you don't want to be caught off guard. You are going through a divorce, and remember, fathers have a chance of winning the custody battle. Yes, you can. However, there's an old maxim of law that says, ignorance of the law excuses not, ignorance about the law excuses no one. And it goes for judges and attorneys. Hello, my name is Chris, and in this session, if you're going through a divorce and you've settled the custody agreement, this presentation is for you because you don't want to pay child support, because child support is voluntary. You can also listen to us on our podcast. We're available on all the major podcasts, Spotify, Apple, and Google. Also, we ask for a donation. Yes, we are asking for a donation. All this research that we're providing, it takes time and energy, and we're just asking for a small compensation just to keep our channel going. And if you have as small as a $5 Cash App, we're welcome. We're asking for a $25 gift donation, but again, any amount will be accepted. This is a reality check. When you go to court, there are 4 definitions for fathers. The presumed father, the alleged father, the biological father, as well as the legal father. When you are getting a divorce, you're deemed the biological father in the case of it's your child or your children, or the alleged father, which is the adoption. And it's very complicated, but you need to learn there are 4 definitions for fathers. In the process of getting a divorce, you're going to demand custody and visitation. you're demanding 50-50 custody. With a 50-50 custody before you get a divorce. Let me repeat. You're going to demand and you need to settle the 50-50 custody, not temporary custody, 50-50 custody before you get a divorce. Because why? Our goal is not to paying child support. Remember, child support is voluntary. You need to settle the custody dispute, and here's why. If you settle this custody dispute, which means support is no longer an issue, and here's the case law. It says, support is not the primary issue, then the remedy is a judgment in the Supreme Court. And the case law is Cordet versus Woods and Salvatore versus Anthony. This is the reason why we're asking and we agree that you are going to settle the custody dispute, 50-50 custody, before you settle the divorce. Getting a divorce is a judicial setting, which is Article 3. Administrative, which is Article 1. Now the difference between Article 3 and Article 1, which is Justice Marshall wrote in the courts that these courts are not constitutional courts, and it's subject to review, which is Northern Pipeline versus Construction, as well as Dorsey versus United States. You are going to get a divorce in an Article 3 court, not an Article 1. You need to learn what is the difference between Article 3 and Article 1. We have another video called Jurisdiction. Jurisdiction is the cornerstone of our judicial process. Without it, you cannot get a divorce. If you are successful, then you'll get a divorce, or it's called certificate of divorce, or the other name is dissolution of marriage. And here's the thing, at the same time, the judge is going to encourage you to get on child support. You need to have a strong objection to that. Really strong objection. The judge will try to encourage you to get on child support or pay something to get on child support. And the judge probably withhold your certificate in event of you need to get an attorney to get on child support. This is a mistake. Because why? You can handle your case by yourself. The judge would like you and ask you to get an attorney. However, the case law says that the right to have counsel, if you don't want one, then you don't have to get one. And the state law is called State versus Pendleton, or Moore versus Michigan State. So the judge can encourage you to get one, but they can't force you to get one. You can handle your case by yourself. You just need to study the law. Now that we know the law, let's consider the statute 28 U.S.C. 1654, and it reads, "In all courts of the United States, parties can plead and conduct their own cases, whether personally or by counsel." So you can represent yourself in court in a divorce court. Remember, and if you get tripped up, then you can see counsel. But a judge cannot force an attorney upon an individual. That's it. This is my opinion. You need to settle the custody arrangement before you get divorced in order to not pay child support. That is, in order to not pay child support, you need to have the settlement agreement for custody. based on the encouragement from the judge, they want you to sign another contract, which is child support contract, which is known as Title 4D. This statute was created or come into existence in 1975. It was part of the Social Security Act. By 1984, they deemed what is called the income withholding aspect of the statute. And then by 1988, it's called the immediate withholding income. So what they're trying to do, the judge is trying to encourage you to join the Title 4D program, which it's another contract. Remember, the divorce contract, when you sign the divorce contract, then you have to sign another contract, which is Title 4D. Remember, you have the right not to participate in the Title 4D program or the child support program, because this is the start of the child support program. I'm going to walk you through how you avoid the child support program. In order to challenge the judge, you will use this case law. It's a very famous case law.
Or otherwise eligible children were denied welfare payments because their mother was cohabitating with a man within the meaning of an Alabama regulation designed to discourage immorality and illegitimacy. The United States Supreme Court considered the validity of that regulation in the 1968 case, King v. Smith. The Social Security Act of 1935 created the Aid to Families with Dependent Children, or AFDC program. The program provided welfare payments to all dependent children defined as needy children with a dead, incapacitated, or continually absent parent. Alabama participated in the program, but had a substitute father regulation in place. The regulation denied AFDC payments to otherwise eligible needy children whose mother cohabitated inside or outside of her in the children's home with any single or married able-bodied man. As used in the regulation, cohabitating meant having frequent or continuing sexual relations. Additionally, the regulation's goal was to discourage immoral sexual behavior and illegitimate births. Mrs. Sylvester Smith was a resident of Dallas County, Alabama, and a mother of 4 children with dead or long-absent fathers. Although the Smith children were otherwise eligible for payments, they were denied AFDC payments solely because Mrs. Smith was having sexual relations with a Mr. Williams on the weekends. Mr. Williams had no legal duty to support the Smith children, and given that he was married with 9 children, he was neither willing nor financially able to do so. Mrs. Smith filed an action in an Alabama federal district court against Reuben King, the commissioner of the Alabama Department of Pensions and Security, seeking declaratory and injunctive relief. Mrs. Smith challenged the substitute father regulation on the grounds that it conflicted with the Social Security Act and the Equal Protection Clause. The district court ultimately agreed with Mrs. Smith and entered judgment for her. King appealed to the United States Supreme Court.
Just to recap, Title 4A, which is custody, and Title 4D, which is a contract, you can't mix the two. You can't mix custody agreement with the contract agreement known as Title 4D. To prove what I'm saying, that Title 4D is separate than Title 4A, here's the case law. In 1975, Congress separated the child support program, which is known as Title 4A, and established the distinction Title 4D program under Title 4D. And the case law is Blankenship versus Blankenship, 4th District, Adams, 1992. So here's proof that child support and on the part D, which is separate than Title 4A. Let's turn our attention to Title 4D. The Supreme Court in 1997, Title 4D is a separate program. It has nothing to do with your custody case on the divorce decree. Remember, Title 4D is a separate program, and the case law is called Blessing versus Freestone. Because Title 4D is not intended to service the mother or the child. The reason why the states get involved in the Title 4D program because the incentive pool.
For fiscal year 2024, the incentive payment pool is established at a total of $713 million. This pool represents the funding that will be distributed to states as financial incentives for their performance in child support enforcement programs. The incentive payment pool is designed to reward states for their effectiveness in managing child support enforcement programs, with a focus on performance, accountability, and accuracy.
I have a video called The 5 Supreme Court Cases That You Should Already Know. It discusses the Title 4D program. Preview the video. I include the self-study guide, which is called the 303 series, which is 45 CFR 303 series. The study guide is 303.5, 303.71, 303.73. This describe the Title 4D program. To know more about Title 4D and the child support, you can review the history of child support. You can review that video. In the course of a divorce, you can sue the judge. And you can sue the judge at any time. And the case law is called Miranda versus Sims, Washington, D.C., as well as Chambers versus Baltimore. You have a right to sue and defend your rights.
Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen or other person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and its laws, is liable to the party injured at law, suit in equity, or other proper proceeding for redress. In any lawsuit brought, the plaintiff must prove that he or she has been deprived of a right secured by the Constitution and laws, and secondly, that the defendant was acting under color of any state law.
Going through a divorce is not easy, as well as emotional. If you have any questions or comment, feel free to reach us at child support, and you can review our consultation. Any questions or comment, you may contact us, chrish@289.protonmail.com. Also, subscribe and like this YouTube video and hit the notification bell. We ask for donation because we do extensive research and it takes time to review all the case laws and all the comments. And we do what is called a selective irrelevance. We ask for a donation.